Yeah, I felt like
I don't want to keep doing this. That's fine.
Sure.
Good morning, Your Honor.
Yeah, they'll be here in a second. I could have walked the long way, but I didn't want to walk around the long way. Just
That's how you've been doing. Good. Keep it busy. Pretty much. Broke out my office.
Yeah.
It was no fun, but it feels much better now. Coming in this morning, got a snack, it was kind of nice. Made breakfast, sat down, read the briefs, said, okay, time to go.
That's another thing that changed.
No, I opened up an office.
All rise. The Ohio Court of Appeals for the Fifth Appellate District is now in session. The judges are the Honorable John Wise, the Honorable Craig Baldwin, and the Honorable Scott Gwynn is presiding.
Thank you. Good morning, everyone. You may be seated. Good morning, gentlemen.
Good morning.
We have a full day here today. We have read the cases in preparation for the arguments here today. Each side has a maximum of 15 minutes to present his or her arguments, and the appellant may reserve some time for rebuttal if he or she so desires. And with that being said, the first case this morning for argument is Swanson versus Maier. Mr. Connolly, good morning. You may proceed.
Good morning, Your Honor. Counsel, Craig Connolly for appellant Timothy Swanson. As Judge Quinn just mentioned, this panel's read the briefs. I was at an appellate argument 2 weeks ago before another panel that will go unnamed, where it was quite clear to me they had not read the briefs. So the moral of the story for me has been I don't need to regurgitate all of the arguments already made. I think my client's primary argument boils down to the proposition that the trial judge rewrote the statute in order to do his version of equity. In fact, he found, I believe, near the end of his judgment entry, that it was inequitable. Yes, he said the awarding a judgment in favor of the plaintiff below would result in an inequitable windfall to the plaintiff. So clearly what the trial court judge did was to rewrite the statute in order to do his version of justice. I think on that basis alone, his decision should be reversed. And I point out to the court the Wright versus Ohio case, wherein that appellate court cited to Ohio Supreme Court jurisprudence for the rather common sense and well-established proposition that it is not the judiciary's function to rewrite laws according to what the court perceives as just. That is exactly what this trial judge did. And unless the court has any questions for me, I'd like to reserve a few minutes for rebuttal, and I'm done talking.
Any questions?
Thank you.
Thank you. On behalf of the appellee.
Thank you, Your Honor. May it please the court, Tom Rosenberg for the appellee, Sheriff Maier. The appellant, Timothy Swanson, claims he is entitled to money personally during the time that Sheriff Maier acted as the de facto sheriff. Mr. Swanson seeks money for work neither performed nor intended to be performed. We're looking at a narrow time frame of February 5th, 2013 to November 6th, 2013. I think it's important to note that there were 2 times that Mr. Swanson was in office as the interim sheriff, appointed first by the county commissioners, second by the Supreme Court. He was paid for those services. In its decision, the trial court relied on State Ex Rel. Witten versus Ferguson. The trial court relied upon letters attached to the affidavit of Sheriff Maier from the state auditor and the county auditor, indicating that while in office, Maier was acting as the de facto sheriff under color of law and would be recognized as the sheriff. The trial court also in its decision concluded Mr. Swanson never desired or intended to serve beyond his 2 45-day appointments. Those are the issues that the trial court determined, all appropriate for it to do so. The trial court also found that its order in denying summary judgment for Mr. Swanson, that judgment was appropriate for Sheriff Maier, finding its order was final and appealable. The 3 assignments of error that are raised by the appellee I will address, by the appellant I will address. The first one is they claim the trial court improperly relied on things it should not have. The transcript taken in this case, an interview posted on YouTube, and the affidavit of Sheriff Maier. The appellant's argument is the trial court should have relied upon nothing other than the first Supreme Court decision. That's wrong. This was a trial case, and the court was entitled to rely on things. In regards to the transcript, first, their argument is solely that the transcript wasn't certified. They don't take exception to anything that is in that transcript. Second, the trial decision doesn't cite to the transcript. The interview, the trial court doesn't cite to it. There is no evidence that the trial court relied upon the YouTube interview of Mr. Swanson. The affidavit of Sheriff Maier. The affidavit basically set forth some basic facts, and then all it said was there was a contention by Sheriff Maier that he believed in good faith, he was qualified at all times to be sheriff, and in all candor, so what, as far as the law goes. And second, the 2 letters. So it was appropriate for it to do so. What the trial court concluded was Mr. Swanson had retired in 2012. He intended to stay retired, as evidenced by his failure to stay credentialed as sheriff, which was very important to the trial court, that he lacked the statutory credentials to be so. And he had no intent to stay as sheriff beyond those 2 45-day times. On pages 9 and 10 of our brief, we cite this testimony from Mr. Swanson, in which he says so. He was retired. What did he want to do? He wanted to go fishing, is what he said. The second assignment of error, which the appellant claims that the trial court erred in denying their motion for summary judgment. Ohio Revised Code 2733.18 allows the complainant in an action of this sort to recover the damages he sustains by reason of a usurpation of office. The statute is clear in that regard. And there was no evidence before the trial court that Mr. Swanson sustained any damages. The appellant's argument is he doesn't have to sustain damages, he just is automatically entitled to it. And the trial court said no. The trial court did not rewrite law. The trial court did not rewrite the statute. The trial court concluded he did not personally sustain any damages. He knew his appointment was temporary. He knew it would be for no more than 45 days, and during that 45-day time period, both of them, he was paid for it. He never indicated any intent to serve longer.
Can I ask you a quick question?
Yes, sir.
On the licensing issue, was he without the license, the accreditation licensing during the entire period that this issue comes along?
He was without the license requirement during the year 2013. There are annual requirements, which is similar to continuing legal education for lawyers.
The period during which he's claiming his damages, basically the salary payments, was he credentialed during that period?
No, sir.
At no time?
No, sir.
Was he credentialed during the periods he was appointed interimly while they were doing the other ones?
I do not believe so, sir. I do not believe he was during those times, but he was appointed as an interim sheriff, both by the county commissioners first, and then when the Supreme Court issued Swanson versus Maier #1, the one that found Sheriff Maier lacked certain credentials. They did put him back in office until the Democratic Central Committee could vote on an appointment. The Central Committee voted, returned Sheriff Maier to office. That led to Swanson versus Maier 2, which found Sheriff Maier had the credentials to be in office.
The purpose of asking the question is if you can be appointed without the credentials for a temporary period, that does not necessarily prevent him then from having the ability to have been the sheriff during that period. Do you understand the correlation? That's why I was trying to see if there's a total block. Is it a total prevention not being accredited, or is it just something indicating he didn't have an intention to do the job?
I think it's he didn't have the intention to do the job by the fact that he didn't have the credentials. The fact that the county commissioners appointed somebody who lacked the credentials at the time, the fact that the Supreme Court appointed somebody who wasn't maintaining his continuing education requirements is not an issue before us, and in all likelihood, those appointments should not have been made at that time. But the issue is, and nobody raised it, nobody raised it to the commissioners, nobody raised it to the Supreme Court. But the issue here is during this time of February to November, he did not have the credentials to be the sheriff, and the trial court used that as proof that he didn't intend to be the sheriff because had he intended to be sheriff, it's not difficult. It's analogous to lawyers. It's not difficult to maintain those requirements. It's taking the class. It's what is needed. Clearly, the third, I will mention the third assignment of error. The third assignment of error is the claim of the appellant that the trial court should not have issued its judgment entry. And here we need to look at two issues. First is the timeline that occurred in the trial court. And I'll just, by way of background, the complaint was filed in February of 2014. There was a motion to dismiss by Sheriff Maier, which was denied. Sheriff Maier's answer was filed after the motion to dismiss was denied in June of 2014. 3 days after it was filed, Swanson moved for summary judgment, was fully briefed. November 17, 2014, the trial court issued its decision. Local Rule 18.01 of the Court of Common Pleas says the prevailing party is to prepare a judgment entry submitted to the other party. If the other party doesn't respond within 3 days, it goes to the court for consideration. What happened here was that was submitted, but rather than respond, Mr. Swanson's counsel immediately filed an appeal on November 21st in an effort to try to divest the trial court of jurisdiction. I think the appeal, in essence, was probably premature because the judgment entry had not gone on. I don't think it matters for where we are here today. But I don't believe that you can do an end run around the local rule requiring judgment entries by filing an appeal to try to stop the trial court from putting a judgment entry on. In regards to the trial court granting judgment in favor of Sheriff Maier, we rely on the Supreme Court case of Detweiler, J.J. Detweiler Enterprises, Inc. versus Warner, 103 Ohio State 3rd, 1999, in which the Supreme Court said, while Civil Rule 56 does not ordinarily authorize courts to enter summary judgment in favor of a non-moving party, an entry of summary judgment against the moving party does not prejudice the moving party, that does not prejudice the moving party's due process rights, where all relevant evidence is before the court, where there are no genuine issues of material facts. It is proper under those circumstances to issue judgment. And while analogies may not be perfect, if somebody comes in and says, I swore the light was red, and the trial court says it wasn't, there's nothing left to decide. And that's what happened here. The court said there's nothing left to decide, and therefore, in reliance upon Detweiler, we also cite to a 2008 case, Todd Development Corporation versus Morgan, the court granted judgment in favor of Sheriff Maier. And it's important to note that in its brief and its reply, the appellant has pointed to nothing to support the contention that its due process rights were prejudiced or that relevant evidence was not before the trial court. In sum, this is really a case about somebody wanting pay for work not performed. And the trial court said that's not appropriate in this case. Mr. Swanson was not entitled to the money, he was not credentialed. The trial court's decision was appropriate, and we ask that this court affirm the decision of the trial court. Thank you very much.
Mr. Conley, rebuttal.
I find it peculiar that counsel is so insistent that the trial judge didn't pay any attention to, at least there's no indication that he paid any attention to the transcript, which was not certified, therefore was not admissible, therefore should not have been considered. But counsel said, well, he didn't consider it. How in the world did he know about this credentialing issue? That was only in that transcript. I wasn't anywhere else. So of course he considered a non-admissible transcript. Not certified per se, not admissible, and otherwise not relevant. And as far as the trial court's reliance upon the Whitten case speaks of public authorities may not recapture money from a de facto officer. This was a private treaty action brought under statute. This wasn't the Board of Commissioners, this wasn't the county auditor, the county treasurer. There's no public authority involved. As far as Mr. Swanson's credentials, he per se was properly statutorily qualified and credentialed. The Supreme Court reinstated him to the position. That alone means the Supreme Court found him qualified. At least hopefully the Supreme Court would not cause somebody to be reappointed who was not statutorily qualified. But even if they did, it's res judicata on that issue. He was qualified according to the Supreme Court. Otherwise, he couldn't have been reappointed and be allowed to wear a uniform like Mr. Maier there and carry a gun. And that's what Mr. Swanson did when he was reappointed. He was the sheriff by virtue of the Supreme Court removing a usurper. As far as Mr. Swanson's intent to be retired, the Supreme Court dealt with that in its opinion too, said it's not relevant. And as far as Mr. Swanson, I guess tied to his intent also, the Supreme Court found in opinion 23 that his, quote, long-term intent to be retired is irrelevant. The court went on to note, quote, Swanson does not assert that he is entitled to the office for its entire current term, but only until the DCC appoints a qualified applicant to occupy the office. That's the term we're talking about. The Supreme Court found the DCC did not properly appoint the first time. Swanson knocks on their door and says, I'm still the sheriff until the DCC properly appoints a sheriff. The Supreme Court agreed. That's the time period we're talking about. From the time the usurpation of office commenced until it ended, until Mr. Maier was properly appointed this second time, because he was not the first time. This is not about equity. This is about statutory interpretation. This is about applying the plain words of the statute to this circumstance. The trial court rewrote the statute, and the trial court in doing so relied upon inadmissible materials before it. And in doing so, the trial court ignored the res judicata effect of the Ohio Supreme Court's opinion. Thank you, Your Honor.